Good evening. This is John Milburn for Laws 12059 Conveyancing. We're into week 6. We are a little behind in terms of the content in the Zoom sessions compared with the reading material. Those of you that are subscribing to the Queensland Law Society newsletters and emails would have noticed today some further information in relation to PEXA, hacks into the system, new security guidelines that have been put in place, and why it's important for firms that are involved in conveyancing, whether they're using e-conveyancing or not. The security measures that have been put in place are common, I guess, to some of the problems associated with cloud storage generally, and it talks about using some responses to the fraud occurrences. One of them is using multi-factor authentication, which is becoming increasingly popular. Personally, I think it's a bit of a nuisance, but it's one of those things we'll probably have to put up with. All right, so tonight I want to start with what is really week 5 material, dealing with formation of contract. So we're talking about the principles, mostly legal principles, underpinning the formation of a contract. And you might think, well, we've already done this. We did this in Introduction to Law. We did this in contracts. It's all very basic. Offer acceptance, communication of acceptance, intention to enter legal relationships, are all just some of the common factors, consideration, of course. But when it comes to dealing with land and interests in land and real estate, it's a little different. So tonight we're talking about some of those differences in the context of formation of contracts and creation of interests in real estate that go beyond basic contract law. So the prescribed reading, of course, is from Chapter 4 of Land Contracts in Queensland, which I think is an excellent text, and I'm sure you're finding that as well. Always, when you're dealing with conveyancing, have at least one of the standard contracts nearby so that you can refer back to the terminology and the procedures outlined in the contract. Speaking of a contract, when a contract is signed in Queensland for the acquisition of real estate, it is usually the protocol to prepare 2 identical versions of the same contract. The buyer signs both copies and presents both to the seller. The seller signs both copies, retains one, and returns one to the buyer. Both are original contracts. One is not an original or a duplicate of the other. They're both original contracts. That's different to other jurisdictions where we have an exchange of contracts, which means that the buyer will sign one, the seller will sign one, and they exchange them. I guess familiarity with the Queensland system, I think it's a good way. It's obvious that both parties have signed the same document, and it's easily established in court through the signatures. But bearing in mind, of course, that when we talk about signing, we're into this brave new world. So coming back to e-technology and commercial practice now, we need to consider new legislation, relatively new legislation, the Electronic Transactions Act 1999 and the counterpart legislation in Queensland from 2001. So there is a need for a signature within the context of forming a contract or an interest in land. And this goes back to the old statute of fraud days. I mean, well and truly repealed, of course, but that philosophy of having to have some signature in relation to a disposition of interest in land or a sale of contract or a contract for the sale of land is embodied in the Property Law Act. So that is something that has continued, but we need to consider that within the context of the electronic signatures regime. Now, of course, I think I've mentioned to you that the Property Law Act is not my favourite piece of legislation. And if you look at sections 11 and 59, it gives you some idea of why I'm concerned about the way in which the legislation is drafted. I'm probably committing all sorts of defamatory comments. It's my opinion, not the university's opinion, but I think it's something that can be improved upon. Now, if we look at sections 11 and 59 of the Property Law Act, people sometimes confuse them. They do mean different things. So section 11 deals primarily with ensuring that equitable interests in land can be transferred by a written document, or in the case of a trust, by a declaration in a written document. Section 59 deals with contracts for the sale of land, and the rule is that contracts for the sale of the land need to be evidenced in writing. So Section 59 deals more with the enforceability of agreements, and it requires some form of memorandum signed by the party against whom enforcement is sought. So there's a difference in philosophy between 11 and 59. But we'll have a look at Section 11 of the Property Law Act, and I'd encourage you to look at this on the screen as we go. If you're watching this as a recorded session, please do likewise. So Section 11 of the Property Law Act deals with instruments that are required to be in writing. Subject to creation of interest by parole, A, no interest in land can be created or disposed of except in writing, signed by the person, etc. So that's the first principle. Second, a declaration of trust needs some sort of writing. And thirdly, a disposition of an equitable interest or trust needs some sort of writing. So if you're reading that section, and I encourage you to do so as carefully as you can, underline the key words so that when you look at that section, you can identify quickly what it means by the words that you've highlighted or underlined. But note the awkward drafting technique. The first subsection is casting negative language, and the second and third cast in positive language. So it's just slightly annoying and difficult to read. Hi Bronwyn, thank you for joining us. We're talking about Section 11 and then on to Section 59 of the Property Law Act. So you'll note that I stressed the word land in the context of Section 11. No interest in land can be created or disposed of except in writing. What do we mean by land? Well, let's go back to our statutory interpretation training. And you would think that land would be defined, but unhelpfully, there is no definition of land in Schedule 6 of the Property Law Act. If you look at Schedule 6, and I'd encourage you to do that now, pan down to land and you'll see, this is how it's defined. Land, ... There's nothing there. And you'll see that's common with a few things as well. All right, so we abandon that definitions schedule. So we go back to the part. We'll see if there's any definitions contained within the part. This part is sections 7 through 18. There's no definition section, so no help there. The Property Law Act doesn't contain an objects clause, so no help there either. Thinking back to our statutory interpretation training, what's the next thing we do? Well, we'll go to the Acts Interpretation Act, Queensland, 1954. We'll see if land is defined there, and it is. But using some horrible terms, land includes, and so it's a inclusive rather than exclusive method of terminology. It includes messuages, tenements, hereditaments, corporeal and incorporeal, and any tenement of any description, and whatever may be the interest in the land. It's a really tough definition. I won't go into what each of those things mean, but it's broad. We can put it that way, and it includes that which is tangible and that which is intangible. Well, yes, Rachel says, how can land be incorporeal? Well, that's really good. Land, because incorporeal means something which is intangible, a chosen action. But bear in mind that we're talking, you're right, how can it be? I actually hadn't thought about that. So how can it be from a real perspective? That's a really good point. I think it's fair to say that when we're talking about incorporeal hereditaments, and I really didn't want to go here too much, but we're talking about that which is both tangible and intangible. Hereditaments means real property that can be inherited. So thank you, Rachel, for that. So let's just move through that, but I'm going to have to think of how, an example of how we might have an incorporeal hereditament and as it relates to land, Incorporeal, intangible property, normally I think of something like a chose in action. Let's move on from that. Sorry, that's a very inelegant definition, but it gets messy. And this really comes back to my point. You'd think that the word land would be easily defined, but it's not, and you have to go all sorts of places to find it. In the Acts Interpretation Act, we also have a definition of interest, which in relation to land means legal or equitable. No surprise there. But remember, section 11.2, the section does not affect the creation or operation of resulting, implied or constructive trusts. Those of you that have done trusts law with Alex McEwen or perhaps myself will remember all about resulting, implied and constructive trusts. Disposition. Now that term is defined in Schedule 6 of the Property Law Act. It means a conveyance, vesting instrument, declaration of trust, disclaimer, a few other things as well. So dispositions are transactions that are not sales, is probably what you can gain from that. So a conveyance, for example, is not a sale. A conveyance occurs as a result of a sale, but it's not a sale, if that makes sense. So a disposition is something different to a sale. That's relevant when we come to a case, and we'll talk about it shortly. Is duty payable on a disposition? I think it probably is, because you may have a conveyance, for example, independently of a contract. And if you do, that may be dutiable. So, yes, there's no reason why a disposition can't be subject to duty. Business transaction, perhaps. Yeah, thank you, Bronwyn. I'm good to see you're thinking. So you're keeping me on my toes. That's good. There are a series of Queensland and New South Wales cases relevant to this. What I'd recommend is coming back to the textbook. If you want to see some good information about dispositions being transactions that are not sales, have a look at page 182 of the current 2016 version of the text, and it provides some good information, good descriptions. So there are a couple of forms of dispositions that must be in writing to be enforceable. For example, agreement by two parties that land be transferred to a third. Often these things are recorded through the transfer, which is a note or memorandum in writing signed by or from the parties to be charged. Now let's have a look at section 59. So we've looked at section 11 of the Act. Now let's look at section 59 of the Property Law Act. And it says that contracts for the sale of land need to be in writing. And it says no action can be brought on any contract for the sale or disposition of land or interest in land unless the contract upon which the action is brought or some memorandum or note of that contract is in writing and signed. So a few key words there. It talks about no action being able to be brought for a sale of land unless the contract or some memorandum is in writing and signed. So there are some definition sections for the division, section 58A, but again, neither land nor interest in land is defined. A good case to look at is Duff and Blinko, 2006 QCA. I'm giving you the unauthorised report version here, sorry. 497. That's the Queensland Court of Appeal. So what happened in this case in Duff and Blinko is this. The parties entered into an agreement in writing. The agreement conferred on the defendants the right to harvest timber from the plaintiff's property, profita pronta. During a conversation, so it's an interest in land, well, we think. During a conversation at a dinner party, this was at Jandowie, the parties reached an oral agreement in relation to these timber rights, and it was reduced to writing. That writing was then reduced again in writing by solicitors. And the agreement said the vendor agrees to sell, the buyer agrees to buy the rights to timber on the land, and in consideration of this, there would be payments made over a period of time from 1990 through to 1992, and the term of the agreement was until 2000. So you'd think that would be all fairly straightforward, but it wasn't. The matter became litigious. Justice Keane, of the then, who was then on the Court of Appeal, now of course on the High Court, made reference to the Property Law Act. And the part that's interesting for our purposes is the way in which His Honour distinguished between Section 11 and Section 59. So my recommendation is that if you have any question in an examination, for example, or about Sections 11 or 59 or both, then keep this case handy and refer to paragraphs 34, 37 and 39 of the judgment. I'll summarise those briefly. His Honour said the Property Law Act observes, in prescribing different formal requirements for different transactions referred to in Sections 11 and 59 respectively, the distinction. And the distinction is between the creation or disposition of interests in land, which is 11, and contracts for the sale or disposition of land, which is 59. Then at 37, His Honour says, Section 59 speaks of a contract for sale, not a contract of sale. Here's where it gets a little bit tricky, but a little bit interesting at the same time. So what His Honour is saying is that a contract for the sale of property is what we call an executory promise to transfer land for money. Executory meaning into the future, and it's a commitment from both parties that they will do something down in the future, that is, exchange land for money, and therefore the contract for the sale is recording something that will happen down the track. It's not a contract of sale. At 39, His Honour says the agreement created an interest in land by conferring on the defendant the right to take as many trees as they wish. The written terms of the agreement were sufficient to meet the writing where the interest in land is to be created, Section 11. Now, it might just be terminology, and we probably don't need to worry too much about this from a daily conveyancing perspective. But again, just keep these paragraphs handy and keep them in your notes in case you ever need to draw this distinction. Now, the problem is that in common terminology, we talk about contracts of sale, don't we? And we do that in the context of the requirements of Section 59. But in reality, if we were to adopt His Honour's wordings, we would not do that. We would talk about a contract for sale. I don't know. Bronwyn, Rachel, you're both conveyancers, aren't you? Or am I mistaken? Do you talk about contracts of sale or contract for sale? Technically, it should be contract for sale.
Yeah, usually I would say a contract of sale.
Yeah, I would too. I would too. So don't be too hung up on about it. Don't start correcting people, but just keep that in mind, that if we adopt His Honour's terminology, which I'm sure is correct, it's Justice Keane, then it would be a contract for sale. And of course, in addition to that, bear in mind, in order to be enforceable, it need not be a contract. A memorandum or note of an oral agreement will suffice. But either way, it needs to be signed by the party or some person lawfully authorised for the party. And that is all I'm going to talk about Sections 11 and 59. Have I confused you, bored you, both?
I was just looking at the actual contract that we've got, and it says contract for houses and residential land.
It does. So it does. So somebody says contract for sale. So I haven't picked up on that, Bronwyn. You're right. But in common parlance, we talk about contracts of sale. But if you're going to be technically correct, talk about contract for sale and go back to that decision as the reason why, because it's an executory promise rather than the actual transfer of land for money. Okay, enough of that theory. Well, don't worry, we've got some more theory for you, but we will get into some of the practical aspects of conveyancing shortly. Now, bear in mind, of course, that what we've been talking about in the context of formation of contracts relates to really offer acceptance type things and enforceability. But we still need to communicate acceptance, and oral communication of an acceptance is perfectly acceptable. If you need authority for that proposition, look at the case of Rymark Australia Development Consultants, that's RYMARK, Australia, against Draper, 1977, QDR 336. Okay, cooling off periods. What legislation do we look at when we're talking about issues to do with cooling off periods? PO Act. Thank you, Rachel. Property occupation. Very good. You're on the ball. Section number that deals with cooling off period? Do we have any votes for the section number? What's the section that talks about the number of days that one has in order to exercise rights under the cooling off provisions of the Property Occupations Act? I can see you're either racing for 166. Very good. Okay, thank you. Straw poll, do you go to Austerley or do you go to legislation in Queensland? I must confess I still go to Austerley first. Austerley, Queensland. Okay, so 1-1. I've got my legislation up. I've got different pieces of legislation on my second screen, and some are in Austerley, some are in legislation Queensland. They have some different purposes, some different advantages and disadvantages. We'll talk about that shortly. All right, so cooling off period. Remember, of course, that irrespective of the day that the contract is actually formed at law, the cooling off period starts the day the buyer receives a copy of the relevant contract signed by both parties from the seller. That may be after the date that the contract comes into existence. So if you see a date on the contract as being the 10th of August, that doesn't necessarily mean that we consider 5 business days after the 10th of August as the duration of the cooling off period. That's a trap for young players, isn't it? So before you can determine the date for the finalisation of the cooling off period, you need to know something beyond the date that the contract was formed at law. You need to know when the buyer received a copy of the relevant contract. So what's good conveyancing practice if you're acting for a buyer, do you think? For residential real estate where the Property Occupations Act does apply. You receive a contract, what should you include in the first letter to the other side? Yes, Bronwyn?
I would call the client to confirm when they actually received it before I do anything and go through the dates with them. Yes,
and what would you do with that information?
Then you can work out the critical dates from there, how many days it is. Once you've got that information, you can sort of take the dates and make sure that everything's as per the contract.
Absolutely. And would you write to the other side?
Yes.
Include it in an email to the other side saying, thank you, we have the contract dated 10 August 2018. We note the buyer received a copy of the relevant contract on 12 August 2018. Therefore, by our calculation, the cooling off period ends at 5 p.m. on such and such date. Okay, I think that's good practice. Now let's just talk on a different area. We're still talking about formation of contract. I want to talk about the issue of certainty and essential terms. It's less common now because of electronic communications, but we used to have issues of something that was subject to contract. So we'd have some sort of note or memorandum or some agreement subject to contract. I'm not sure if you've ever come across that. But when conducting conveyancing, you need to be clear as you can, express what you're authorised to do on behalf of your client, and you need to deal with certainty issues. So one thing is subject to contract, and it may signify an intention not to be bound immediately, but the courts look at the surrounding circumstances. But independently of that, when you're undertaking conveyancing, make sure that you're clear on what it is that you're authorised to do and what you're not allowed to do. So I know I'm mixing some concepts here. Let's have a look at a case. Moffat Property Development Group against Hebron Park, Pty Ltd, 2009 QCA 60. Again, I'm sorry to give you the unauthorised report. I shouldn't do that. Moffat Property Development wrote to Hebron Park's real estate agent. Moffat offered to purchase 20 acres of rural residential land at Forest Glen on the Sunshine Coast. It specified a purchase price, the deposit amount, and settlement 12 months from the date of contract, which was in the form of an unconditional put and call option. So this is a letter, an email to the real estate agent. Hebron Park, which is the owner of the property, signed the letter and returned it to Moffat Property Development, and then Hebron tried to pull out of the deal, and Moffat said no. Now here's what the letter said. Purchase price $3 million, $500,000 non-refundable deposit released when the vendor signs the contract. Contract will be unconditional in the form of a put and call option. Settlement 12 months from the date of contract. The vendor to remain responsible for insurance until settlement. And this is what was in the email letter. We do require security over the land to ensure our deposit is secured in the form of a caveat or mortgage. If the vendor accepts this offer, please sign off on the letter of offer as accepted, and we'll instruct our lawyer to prepare a contract. So here's an example. So the situation is the buyer has written to the real estate agent and said, we want to buy the land, and set everything out in the email. Please have your client, the owner of the property, acknowledge that that's fine. The response came back and it said, I, Kim Edwards of Hebron Park, acknowledge acceptance of the offer for the land at Forest Glen, and that was it. So now Hebron are saying, no, we're not going ahead with that. Moffat say, yes, you are. So we've got a case. And again, the lead judgment by His Honour Justice Keane. So the Queensland Court of Appeal held that there was a binding agreement for the sale of land, ordered the parties to prepare and execute a put and call option to document the sale. The parties intended to be bound by the transfer of land by exchanging the letters. They were unconditionally signed and exchanged in that sense. And the idea of the formal put and calls was simply to formalise the arrangements. The court rejected the argument that the letter was uncertain. It did specify enough. It didn't say when the deposit was to be paid. It didn't say the place for settlement, but the court said that's not fatal. We've still got enough of an agreement by the exchange of the emails to be certain. So where I was mixing concepts before, what I'm really saying is that you may have something which is an exchange of emails, for example, which appears to be subject to contract. The important thing for conveyancers is when you're undertaking conveyancing, be very clear about what you are authorised to do and the extent to which your client intends to be bound by your communication. It may be that the person who wrote the email had no intention of being bound or didn't believe that the organisation on behalf of whom they were writing had authorised them to make that statement. But objectively, they were bound. I hope that makes sense. So on that point, I suggest that in Queensland, the essential terms are best described as the 3 Ps: the parties, the property, the price. In my view, you can still comply with Section 59 requirements, provided, of course, there's some note or memorandum in writing signed by the party or someone authorised on behalf of the party, if you've got parties, property and price. You don't need to have a date for completion. The court will read that in. It will be a reasonable time. You don't have to have a deposit at law. In other words, one party could enforce the issue. You'd probably need to serve on the other a notice to complete and give them reasonable time to complete the document. Now, that's only my view. Does anyone have a contrary view? You're allowed to. That's a good thing about law. There's not necessarily a right or wrong answer. Well, sometimes there is. All good?
I've actually got a case of that today I was working on. We've had an offer put to a client. Initially it was like an offer to purchase their house, and it's on a 12-month contract. And initially it sounded like a put and call option when the client came to see me. We're acting for the seller. And it sounded like a put and call option. And then we got in touch with their solicitor, and he obtained instructions and sent something over. But because it was through a solicitor and not just through the agent, because the agent didn't even understand the concept of the put and call. He thought it was just a sale with a 12-month term, but it was actually a put and call option on a house. But the solicitor put all sorts of disclosures in the letter to them, as we did on our response.
So very wise practice, to be very clear. So thank you, Bronwyn. That's amazing that's something that you've been doing today. All right, so the message from both Bronwyn and I, make sure that you include appropriate disclaimers and be very clear. Now, in Section 59, it talks about writing. Any form of writing will suffice. As I often say, a serviette in a restaurant, provided you have those essential elements signed by the parties, would be sufficient to be enforceable, I think. All right, let's talk about the Electronic Transactions Act, Queensland, 2001. I mentioned it briefly earlier. Section 3 deals with the objects. Section 4 deals with a simplified outline. So have a look at those sections. And Section 5 refers to a flowchart. I thought, well, that's interesting, but it's not, you can't find it in OSLI. It's not in OSLI, but you will find that flowchart in the legislation Queensland version. I mentioned before, I think both platforms have their advantages and disadvantages. I usually go to OSLI because it's generally a bit easier to find the sections, but now the new legislation platform is so much better than it used to be, so that's less of an advantage. But I think NoteUp is a very good case citator in OSLI, so it's almost like a first point of call for me. But if I want to know anything about the versions, the point-in-time versions, I definitely go to legislation in Queensland. So the point-in-time versions, of course, relevant if you need to know what the law was at a particular point, which may be relevant if you're dealing with an issue that arose some time ago. Right. Also, on the Electronic Transactions Act, I'd invite you to read sections 7A, where the Act does not apply to particular transactions, and have a look at Schedule 1, which talks about excluded transactions, and note that there are 16 subsections, but have a look at subsections 1 and 5, where it says that the excluded transactions are requirements or permissions for filing documents or documents that need to be served personally or by post. So I know that's quick, but I'm just inviting you to read those sections in particular. On the same piece of legislation, have a look at Schedule 2 Dictionary, which talks about consents. Includes consent can be reasonably inferred from the conduct of a party. Section 8 deals with validity of electronic transactions. A transaction is not invalid under state law merely because it took place wholly or partly by one or more electronic communications. And look at section 11, which is the requirement to give information in writing. If under state law a person is required to give information, then that requirement is taken to be met if the person provides it by electronic communication. A relevant case, which deals with section 11.2 of the Electronic Transactions Act, is Rockhampton Regional Council against GK Resort, 2013 Queensland Planning and Environment Court, QPEC 40. And in that case, it talks about the issue of consent. May be reasonably inferred by the fact that the person who lodged submissions by email with only their email address is likely to consent to receiving notification by email. Have a look at section 14, which is the requirement for signature. And it says, if under a state law a person's signature is required, then the requirement is taken to have been met for electronic communication if the method is used to identify the person and the method used was either reliable as other forms, or proven in fact to have fulfilled the functions, and the person to whom the signature is required gives consent. Let's talk about a lease case. For those of you doing land law with me, I'll also talk about this in land law, I suspect. So it's dealing with leases, but for our purposes, in the context of written requirements and electronic communications. It is Luxottica Retail Australia against 136 Queen Street Proprietary Limited, 2011 QSC 162. This was an application for an injunction case. The applicant was the lessee, the respondent the owner, the lessor. The applicant leased the premises from the respondent. This was in Queen Street, unsurprisingly, to operate their flagship store, Sunglass Hut. I don't know if anyone knows that store, but that was the case. So before the registered lease expired, the applicant and the respondent entered into negotiations for a new lease. The negotiations continued after the term of the registered lease expired, and so the applicant, the lessee, was holding over pursuant to the terms of the old lease. Now, the applicant said that there was a new lease formed. The respondent said there was no new lease formed. So it's a little bit like the case that we were talking about previously, where there's an argument about the exchange of material, correspondence, and what people meant by that. So the lessee brought an application, sought an interlocutory injunction restricting the respondent from taking steps to retake possession of the property and put another tenant in. The question for the court was, should we grant the injunction? And the court considered Property Law Act Section 11, Property Law Act Section 59, and the Electronic Transactions Queensland Act Section 14. So here's the critical email exchange. And when I've finished reading it, I invite you to tell me what you think the court would say. So by email on the 20th of April 2011, Hanscom wrote to Hess and said, we've now received acceptance for Luxottica's offer. We will prepare formal lease documentation urgently. We look forward to receiving or finalising this matter for you. So that was the agent. By email on the 27th of April, a week later, Hanscom again wrote to Hess and said, there's been some confusion over your offer for the premises. Although the owner would prefer to accept your higher offer, we have already accepted another offer, and he feels he has to honour that agreement, albeit at a lower gross rental. This means the owner will give you notice that the holding over has ended, and we apologise for the confusion. So the applicant said, no, you can't get out of it, sought the injunction. What do you think the court said? Maybe I may have read that a bit quickly. Agreement or no agreement? I think the key word, yes, Rachel?
Hey.
Yeah, the court agreed. I thought it was pretty clear that it was. So Justice Anne Lyons said it was argued that Section 59 had not been complied with, which requires a note or memorandum in writing, and that there was no essential terms of the alleged agreement. But the court said it would seem clear the requirements of signature had in fact been satisfied given the provisions of Section 14 of the Electronic Transactions Act. That section provides for the requirement for a signature to be taken to have been met for the purposes of electronic communication if the method is used to identify the person and the person's approval has been given and the signature and there's consent to the requirement being met by that method being used. So in the end, the court held that there was sufficient agreement and that there should be an injunction which was made in that case. So again, that case is handy because it's useful to discuss what is meant by Section 59, this memorandum or note in writing, what is meant by signing, and what is meant in the context of electronic signing. So that was sufficient. Now that's in the case of a lease. Yeah, and Bronwyn says quite rightly, wouldn't the agent be in trouble if the lessor had agreed with somebody else? And that's exactly what had happened. So now we have two people purporting to lease the same premises, and the court said, no, the original person has every right to stay there. The landlord has no right to move in. So the landlord more than likely was then exposed to a damages claim from the disappointed prospective tenant who had planned to move into the premises. Okay, so that's the concept of writing electronic transactions in the context of a lease. Now let's look at one for a sale. The case is Stellard, S-T-E-L-L-A-R-D, Proprietary Limited, against North Queensland Fuel. This is 2015 QSC 119. Stellard was prospective buyer of a service station. North Queensland Fuel, the prospective seller. The question for the court was whether a contract had come into existence regarding a service station in North Queensland. North Queensland Fuel, through an agent, wanted to sell, sought expressions of interest. Negotiations took place between the parties via email. Stellard offered subject to contract. North Queensland accepted subject to execution of the contract. Familiar story. Did the emails constitute a contract? Had the parties reached an agreement as to all material incidents of the proposed transaction? Were the parties legally bound? Were the requirements for signature satisfied in accordance with the Electronic Transactions Act, Section 14? They were the questions for the court. The court also considered Section 59 of the Property Law Act, and it considered a case that I'm going to ask you to keep in your arsenal. It's Masters against Cameron. I'll give you the official authorised citation this time, 1954 91 CLR 353. So within the context of those questions for those facts, the court considered those pieces of legislation and Masters and Cameron. So what were the arguments? The plaintiff, Stellard, said there is a contract. It was constituted by the email exchange between it and North Queensland Fuel. The defendant said, North Queensland said, no, there was no intention to be legally bound by the exchange, and anyway, there was insufficient written memorandum or note to satisfy Section 59 of the PLA. Justice Martin said at 24, the paragraphs that I want you to look at are 24, 40, then 64 through to 70. So paragraph 24, Justice Martin said, to be legally enforceable duty, there must be identifiable parties to the arrangement. The terms of the arrangement must be certain, and unless recorded as a deed, there must be real consideration for the agreement. Well, that's pretty straightforward, so we're right with that. Then at 40, His Honour said, it is not the subjective beliefs or understandings of the parties about their rights or liabilities that govern the contractual relationship. What matters is, by the words and conduct, what would a reasonable person in the position of the other party believe? So I mentioned that briefly before. It didn't really matter what people actually intended. We're looking at an objective test here. So paragraph 40 is authority for the fact that we're going to look at this from an objective perspective. Then paragraphs 64 through to 70 conclude the case. His Honour talks about section 59 as it's affected by section 14 of the Electronic Transactions Act, and said that the argument mounted by the defendant is not that the acceptance email would not satisfy section 59, but that it didn't satisfy section 59 signature requirements, which is supported by section 14 of the Electronic Transactions Act. And in this case, the court held in favour of the plaintiff, so again supported the notion that there was sufficient evidence in that case to support a finding that an agreement had been struck and the writing requirements under section 15.9, as supported by section 14 in the Electronic Transactions Act, were sufficient. All right, you're doing well. What I'm going to do is wrap up reasonably soon. I just want to talk about doctrine of part performance, and then I'm going to come up with another case for you to consider. So part performance is an equitable doctrine, and it enables justice to be done where a party has performed something that might otherwise be unenforceable due to non-compliance of the statute in fraud. So this is where it gets even a bit messier. An equity will consider the actions of a party's part performance to a contract, and it may give effect to that, notwithstanding non-compliance with this statute of frauds. Equity will consider the actions of the party's part performance if what the parties do is unequivocally referable to a contract, albeit unenforceable. Refer to Millet and Regent, 1975, 1 NSWLR 62. The idea is that this doctrine guards against a party unconscionably taking advantage of the strict requirements of the statute of frauds, the requirement for writing, where the other party has acted under a misapprehension that a properly enforceable contract does exist. Does that make sense? So what I'm really saying is, take all of this, the information we've talked about tonight, in the context of sections 11 and 59 and section 14 of the Electronic Transactions Act, but just remember the equity may intervene if there's sufficient part performance to justify proceeding irrespective of the technical failures to comply with the written requirements. Okay, let's, this is case number 9. So I think you probably realise that most weeks I give you a case, so we're up to, or maybe 2. So this is case number 9. So I'll invite you to listen carefully. I'm not necessarily going to provide an answer to this one. It's more, can we identify the issues concerned? So here we go. You're a conveyancer. You're acting in a law office. You act for a buyer. The buyer requests you seek an extension on the date for settlement for 24 hours. You contact the seller's solicitors. You do that by telephone, and you wait on the line for a response to your question. So you're on the phone to the seller's solicitors. You wait for 5 minutes. Your counterpart comes back to the phone and says, yes, the seller agrees. The next morning, you arrive at work at 8:30. The first email you see is from your counterpart advising that their client has elected to terminate the contract due to your client's failure to settle by the due date of the contract, which was yesterday. So I forgot to say that the settlement was on that day. So here are some questions. Can the seller terminate the contract? What strategies would you consider available to the buyer? And would your response be different if the buyer had paid some consideration for the extension? Let's say you had that in an exam, in a take-home paper, that type of scenario. What are some of the issues that immediately come to mind? I'm not looking for answers now, I'm just looking for you to identify the issues that might be relevant.
Whether it's in writing.
Yeah. And more than that, time is of the essence and undertakings. Yes, that's really good. Whether the statute of fraud requirements apply to the variation. Okay, so what did you say, Rachel? You said, was it time of the essence?
It was an undertaking.
Right. Well, was it an undertaking? Who gave the undertaking?
The other side's conveyancing clerk.
Did they? Did they say the words, I undertake? Do you need to have those words for it to be an undertaking? Maybe. It might be implied. And bearing in mind, we're not giving answers now, we're just raising issues. So you can think about this.
Given that they went away for 5 minutes, you would assume that they actually did contact the seller.
Mm-hmm. Well, yeah, your counterpart came back to the phone and said, yeah, the seller agrees. But we've said this, one of the features of tonight's cases, isn't it? A series of cases where you've had what you think is an agreement, and then one of the parties comes back and says, no, I'm sorry, I'm not proceeding with that. It wasn't a formal agreement. It wasn't in writing. We weren't legally bound. We didn't, things of that nature. Right, so we've raised three things. Can the fact that it's verbal, does that make any difference? Does it make any difference if it's in writing or not? Bearing in mind the statute of frauds. We've raised issues to do with time is of the essence. Undertakings. Bronwyn says, you should follow up the telephone call with an email confirming your discussion. Well, I think that's a good idea. From a practical perspective, that's a good idea. Legally, does that take us any further, or is that only evidentiary? Do you know what I mean by evidentiary? Something that you can use in evidence. But does that change the legal issue? Has anyone heard of equitable estoppel? I know we're talking equity now, rather than pure conveyancing.
Waltons and Marr.
Walton, Store and Marr, yes, very good. Yep, okay. So maybe you'd think about that if you were preparing an answer for a take-home paper. It's sounding like I'm giving a hint. I'm not necessarily giving a hint. I might be. All right, what else would you think about? What other issues? Has anyone heard of waiver? Would waiver be relevant? Maybe. Do you think there's been professional misconduct here?
I read somewhere there was a case where there was misconduct where someone didn't seek an extension.
Yes. And then the next question is, well, who was committing the misconduct? The person who said, yes, we agree to tomorrow, or the person who failed to record that in writing? I don't know. So maybe professional misconduct. Another thing is, was there, what would be the date of adjustment of outgoings? In those circumstances, what do you do? It's not necessary. I'm not giving any answers. I don't have an answer. I'm really just raising issues for you to consider.
can you question also the time of the essence? Because, I
Mm?
mean, in my experience, things often get held up a day or two.
Absolutely. So I would say to myself, well, if you're going to play that game, did you reserve time as of the essence? If you now purport to terminate, can you lawfully do so, or do you now need to give us notice to complete and give us a reasonable time to effect settlement? Maybe that might be another answer. So there's a few issues there, isn't there? So what we'll do next week is I'll pick up on this point and we'll explore a little more, not in too much detail, but we'll talk about waiver, we'll talk about equitable estoppel, and yes, Walton Stores and MAR was on my list of things to talk about in that context. So well done. Okay, any questions about what? All good? All right. Thank you very much for your attendance, and we'll see you next week. All the best. Bye then.